question page. You are free to take notes. However, when we are done, I'm going to give everybody the same questions with the answers. But you don't get them yet. Because this is a post-lunch seminar, which means people are starting to get sleepy from all the digestive juices working. That's not going to, no one's falling asleep in here, folks. It's not going to happen. One of the reasons why is, if we see anybody starting to sleep, Michelle is going to zap you with the GSMOL taser gun. That's typically only used on park owners, but today, we brought it along. Bob Marquis used it more times than he can count. Just talked to Bob about all the park owners he's tased. And the second thing that is going to prevent us from falling asleep is this is going to be an extremely interactive presentation. I'm going to be asking these questions and you're going to be giving me answers. So we're going to see how well you know what it is we're going to talk about. What we're going to talk about today is the Bible, mobile home residency law. This should never be kept too far away from you. Hopefully it's not boring enough to put you to sleep when you have insomnia. It may be. The estate planning documents I prepare really are that boring. But it should be in a closely guarded, well-known place so that you can just whip it out whenever you need it. If my friend Ron Jabor from HCD was here, the HCD attorney, he would say, this is actually the New Testament. The Old Testament is Title 25, which is the Building Codes and Standards for Mobile Home Parks. So, just to let you know, we're not going to talk about Title 25 today. Title 25 is how wide do carports have to be, how much square footage of shed can you have on your property, all that kind of fun stuff. That's not what we're going to talk about. This is the landlord-tenant management-homeowner relationship, okay? HCD doesn't have any jurisdiction over this yet. But for now, this is an issue that concerns us because this is a consumer protection law and we need to know it. Just so you know who I am, I'm Bruce Stanton, Corporate Counsel for GSMOL. My second hitch of duty, 90 to 96 was my first, 2009 to present, so it's been about 15 years or so of doing this. I grew up living in a mobile home in Morgan Hill, California when I was in high school. So my dad was GSMOL chapter president. I think the civil code was probably about 3 pieces of paper, front and back. Space rent was $50. There were turkeys at Thanksgiving in the clubhouse, and probably roast beef or something at Christmas, and those were the days, right? So I never met a park owner I liked enough to have as a client. So I represent mobile home residents. That's what I do. And I sleep well at night. So that's a little bit about me. And my introductory comment is going to be brief because of the time that we're allotted here. But just so you know, in the welcome, I talk about the MRL Roadshow. When I came back to GSMOL in 2009, we started planning and putting on these civil code gatherings just like this. We called it the Roadshow. Probably royalties are due to Bing Crosby and Bob Hope for that, but they're not around anymore, so we get away cheap. And we used to do these in about 3 hours, actually. Presentation, Q&A, there'd be some co-presenters. Henry Heater from San Diego used to come with me and some others. I only got 50 minutes, now 45. So this is going to be, you know, racing through to some degree. But I just want to emphasize to you all that information is power, right? If you don't know your rights, can you enforce them? Absolutely not. The more people we empower, and for those of you here today, your job is to go back to your parks and empower others and make sure they have a copy of their code and that they know where to get the resources and find out about the laws and how to deal with the problems that they're going to have. And that's why we exist. We have the information, the database. Can you only imagine? There's 1 million mobile home residents in California, folks. Can you just imagine what would happen if we just got 100,000 of them really organized? GSMOL used to have over 100,000 members. That was the good old days also. Back when Lawrence Swelk was involved and owned that park in San Diego or Santa Barbara, wherever that was. Best Harper owned a park too. Daniel or Baby Crockett owned a park. But we need to revitalize and get people to not be apathetic and wake up and be organized so that when the trouble comes, there's a way to deal with it. So, let's launch into some questions here, because this is, as I said, the Bible, at least the New Testament. This is a consumer protection law. And it's very important that you understand this. Now, what I'm going to do is I'm going to go through these questions, and then I'll take other questions at the end, but I'd like to just stick to these questions, okay? Because it's going to lead us through some of the key areas of the MRL that I think are important for you to know. Question number one. Everybody have any questions?
Yes.
Who enforces the mobile home residency law?
We do.
Courts. Go on.
I heard the courts.
We do.
We do.
We do. How many say we do?
Yeah, park owners too.
Well, yeah, the park owners should definitely follow it. But in terms of enforcing your rights and making sure that it's followed, it's you. Look to your left, look to your right, like they told me in law school. One of you won't be here in 6 months. But you do. There's no MRL police force. Would that there was. Would that we had the state budget. Maybe we could take some of that high-speed train money and we could actually hire and deputize people that have little MRL police armbands on. Right? And they would be out there just in every park just watching for violations, but that doesn't exist. So it's up to you guys. Now, help may be on the way for that. And I think next hour, maybe there'll be a little bit of information that Esperanza will share with you. But for now, this is a statute that is enforced by you guys. And when I say enforced, I don't mean you guys become DAs and judges, but you have to go find those people to get it enforced. Usually it's not going to be a government attorney or a government agency. Once in a while, we have superstar stories like that. Back in the early 90s, when your president was in San Jose, we actually got the district attorney of Santa Clara County to sue a park owner for lease fraud, and it turned into a $500,000 judgment against the park owner in penalties, and all these fraudulent leases being blown up. And you can read that case for yourselves. It's published, called People versus Beaumont Investment. Tatum and Kaplan was the park owner. So those stories happen, but they're few and far between. Basically, that's why you guys need to know this stuff, because if you don't know, and you're the one who has to enforce it, where are you, right? Question 2. Is a trailer or an RV, I know trailer is a dirty word. I'm talking about a real trailer. I'm not trying to call it your home trailer, because we know they're not. But is a real trailer or an RV treated the same as a mobile home?
No.
Under the MRL? Correct, no. What's the only time? Well, I'll say no, but for the most part, the answer is yes. If the RV or trailer has been in the same spot for how long? Does anybody know? 9 months. If a trailer or an RV has been in its space for 9 months, it's treated just like a mobile home under the MRL, with one big exception. Maybe you know what that one is? Even if a trailer or an RV has been in place for 9 months or more, it does not get protection at resale like a manufactured mobile home does. In other words, the park owner can require that it be moved out of the park. Park owner cannot require that a manufactured mobile home be moved out of the park on resale, unless what? Does anybody know? Health and safety. And then the other term is significantly run down or in disrepair. Anybody got a definition for that? Maybe condemned, but it's subject to some discretion, obviously. But that's the one difference. Otherwise, if an RV or excuse me, a trailer has been in the space, the rented space, in a mobile home park for 9 months or more, it's treated the same. Are you a homeowner or are you a tenant? Raise your hand if you're a homeowner. Raise your hand if you're a tenant. Raise both hands if you're both. Yes, you're actually both. For most purposes, we always want to say we are homeowners. Am I still in the shot? Am I moving too much?
It's the entire thing.
Good.
You can move around.
I'm used to it. You are both because you are defined as a homeowner for purposes of this consumer protection law, but you are also a tenant in terms of basic landlord-tenant law. You have a tenancy in the park. So basically, you're a homeowner with a tenancy. That's what you are. But you're not just a renter, and you're not just a tenant. This was an extremely, extremely important word that GSMOL got passed into this law many years ago. Because it is, the connotation of homeowner is completely different from tenant, as we can all appreciate. And this is one of the tasks, obviously, that we've had as advocates for mobile home park homeowners, to educate judges and courts, because people don't get it. If I could sing, I would say they think it's that trailer for sale program. Remember that song? You can't believe how many times we've dealt with DAs, judges, people in government, and they just look at you and go, well, what are we really talking about here? And it's like Vince Lombardi used to say, you know, when the Green Bay Packers would lose a game, he'd go in on Monday and hold up a football and say, gentlemen, we need to get back to basics. This is a football. And that's what we literally had to do in that DA case in Santa Clara County. We had to call the DA, the deputy DA and investigator into the GSMOL San Jose office and say, this is a mobile home. And start there, because they just don't know. So being a homeowner, it's extremely, extremely important that we have that title. Now, number 4. Certain documents are always deemed to be incorporated when you sign a rental agreement with the park. They become part of your homeowner tenancy package. Does anybody know what those are? All right, so I heard MRL, that's correct. I heard park rules, that's correct, or CC&Rs if they exist.
What about RSOs?
RSOs are not incorporated in your rental agreement. That's a whole rent stabilization ordinance is what Shirley means. That's a whole separate ordinance. But what the code says specifically is that the park rules and the mobile home residency law is deemed a part of your agreement. So what you need to envision in your mind's eye is this booklet here is physically stapled to your lease or your rental agreement. And that becomes very important because, question 5, if a park rule or rental agreement contradicts the mobile home residency law, which one applies? The MRL always applies because it's a state law, not some document that a park lawyer created for his client. And this is attached to what the park owner lawyer created for his client and is deemed to be a part of it, so you see it can't contradict it. The state law will always govern. I don't think this was a separate question, but a related question is, if I am a tenant, a homeowner with a tenancy in a mobile home park or manufactured home community, can I waive any part of this? Can I say, you know, I really like the manager. I know I'm entitled to a 90-day notice of a rent increase, but I like the manager, and it's a hassle for them to give me 90 days. I'll just agree, just give me 30 days. 30 days is fine. I don't really need to have that protection. Can you do that?
No.
Absolutely, you cannot. This is a consumer protection law, and the law presumes that if you wanted to waive any of these rights, you don't know what you're doing.
Right.
That's really what the law assumes. The law is assuming, why would anybody waive any of these rights? And if you are waiving them, you're either under duress or you just don't know what you're doing, and we're going to help you know. So you can't waive any part of this. This stays in effect and must supplement and guide any other documents that are created. Number 6, very interesting question. Do prospective buyers have the same protections as mobile homeowners when it comes to the offering of leases or rental agreements?
No.
Buyer comes into the park office, do they have the same protections?
No.
Raise your hand if you think they do. Some people think they do. Actually, they don't. And the reason is, this law protects, who did we say?
Homeowners.
Homeowners. When do you become a homeowner? When you buy, you close escrow, and you sign what? A rental agreement. Until you sign a rental agreement, you're not a homeowner, thus you're not covered by the MRL yet. So it's like a little bit of a catch-22, right? I want to get covered by the MRL, so I have to sign a rental agreement, but by the time I sign it, it's too late to get the protections that I would have got as a homeowner. So what's very, very important, folks, is if you live in a rent-controlled jurisdiction that has a rent stabilization ordinance, we call it an RSO, it's very important that the local government patch this hole. And they can do that by a clause in the ordinance called a prospective buyer protection clause that says no buyer can be made to waive rent control as a condition of tenancy. Meaning you can't make somebody sign a long-term lease as a condition of buying in the park. But that has to be done by local government. All of the lease protections that you all have as homeowners, new buyers don't have them, and there's actual cases that have said that. Years ago, GSML tried to get new buyers protected the same as homeowners. It happened right after I became corporate counsel the first time in 1991. And unfortunately, the way it was drafted, it was preempting local rent control. And Senator Bill Craven, who was our champion in those days, had to actually remove the legislation about 6 months after it was passed, because it was preempting the local governments. So it's pretty much stayed just that way. Number 7, can management offer you a TV or a microwave oven to get you to sign a lease?
No.
Actually, they can't. What's the one thing they can't offer you to get you to sign a lease? Less rent, Diane says. Absolutely right. Winner, winner, chicken dinner. They cannot say, if you sign this 5 or 10-year lease, I will reduce your rent by $100. They can give you a TV or a microwave. Maybe you should hold out for something better than that. We'll talk about that issue in a minute. But they cannot offer you a rental reduction. That is seen as the carrot and the stick routine. Too much stick, not enough carrot. Number 8. Which leases or rental agreements are exempt from local rent control? If you have local rent control, which rental agreements that you might sign would be exempt? Long-term leases, what does that mean?
Over 12 months.
I heard over 12 months, that's correct. If the rental agreement exceeds 12 months in length, while that agreement is in effect, you're exempt from local rent control. There's one other thing that has to be in that document at the very top of page 1. You know what that is? 798.17 says you must have in 12-point type a certain magic language that says, this lease or rental agreement shall be exempt from any local law regulating rents. It has to be right at the top of the document. If it's not there, it doesn't matter if it's a 2, 5, 10, 50-year lease, it's not exempt from rent control because that wording language isn't there. If you sign an agreement of any length, or especially the long-term lease, I should say, and you signed it in the manager's office and you go home the next day, you wake up the next morning and you go, what have I done? Can you get out of it?
Yes.
How long do you have?
72.
72 hours. And most importantly, we got this law passed a few years ago, and I remember being in the conference in Sacramento about it. The problem we were having is people would sign these documents, and then the manager would say, Tony, I'm going to get you a copy of this just as soon as I get my printer working. Or just as soon as the home office down in San Ysidro gets back to me. And guess when Tony gets his copy? About 73 hours later. Right? Well, now the law reads that the time doesn't start until you get your fully signed copy, which only makes sense. GSM law got that passed. Number 9, different kinds of lease terms that must be offered. If you're a homeowner and you're living in the park and they're offering you rental agreement, what must you be offered? What kind of terms? Meaning the length of the agreement. Month to month? 12 months? Or long-term if the park owner wants to offer you that. You can't make the park owner offer you long-term. Although I'm sure if you said, I demand you give me a 10-year lease, they may be more than happy to do that. But you are required to be offered a month-to-month or a 12-month. Very, very important, however, this question. Number 10. Critical question. If you're an existing homeowner, can you be told you must sign a new rental agreement?
No.
I'm so happy to hear the chorus of no's. You can never be made to sign a new rental agreement once you have signed the original one when you bought the house, when you moved into the park. That's when they can say, you've got to sign a rental agreement to become a homeowner and have a tenancy in my park. But they can't come to you 10 years later and say, you know, we're updating all of our files, and we noticed that there's no rental agreement in your file, and so here's just a standard thing, and you need to sign this. The answer is no. You don't have to sign it. I'll give it to you. You don't have to sign it because there's nowhere in the MRL that says you do. Another important question, because we're going to start talking about park rules. I've had this subject come up a number of times in the past few months, reviewing rules and regulations packets. I just reviewed a set for Ellen Duke in Central Coast area a couple days ago. Big, thick packet of park rules, 25 pages. You have to sign at the end of it. Do you ever have to sign park rules?
No.
No. If you sign park rules, what does it become? A contract. It really becomes a legal contract. Never sign park rules. I mean, I would say if they only want you to sign something that acknowledges you received them, that's okay. But you have to be real careful with that language because it might say, I acknowledge that I received them and that I agreed to them all. You don't want that. You know, only acknowledge receipt, but you never want to agree to park rules as a contract because then they can be enforced that way. Number 11, do park rules apply to park managers?
Yes. Yes and no.
I knew I was going to get Shirley's answer because I was looking for the legal answer, not the practical one, and Shirley gave us both, yes and no. Legally, the park rules do apply to park managers. The only exceptions are? Age, that's right. The first exception is if you have a senior park, the managers don't have to be 55 or 62. And what's the second one? Children, but there's another one too. If the park has a rule that says no parking in the street, and the manager's reading the utility meters, can the manager park the golf cart in the street while he's reading the utility meters? The answer is yes. So in the performance of their duties, they can depart from the rules, but that doesn't mean they're violating your rights in the process. We draw the line there. But there may be technical non-compliance. Practically speaking, I know why Shirley answered the way she did, because we all might say, yeah, they're supposed to apply to the park managers, but you know, we know they don't. We know that's a significant issue. It's a significant issue around the state. Another reason why knowing this law gives you that power, you know, to object to that. Number 12. Now we're talking about Amending park rules. Can park rules or regulations be changed without a meeting with the homeowners?
No. 30 days notice.
That is correct. They must give you a written notice that says, here are the new park rules that we're thinking of or that we are going to now enforce. And here is a 10-day, at least a 10-day notice that we're going to have a meet and confer. Now, I've been to these meetings. How many of you have ever been to any of these meetings with the new rules? Okay. Sometimes you have a responsible park owner or management team that says, we're actually interested in what you think of these because we got to enforce them, so we kind of like to know ahead of time if you're not going to follow them. And you'd think that would be what everybody would follow or what they would want to implement. I've actually been in these meetings. I've been hired to come where the management sits at the front of the room, says, here's the rules, folds their arms, and people ask questions and they go, I don't have to answer that, I don't have to answer that, I don't have to answer that. And it's really a sham. And so I would question whether or not they followed the MRL in that situation. It's important to know that they do not have the obligation to change their rules if you say you don't like them. Okay? Because they own the land, it's their property. But there's that very important word that we're going to get to in one of our other questions that sort of continues that thought. Number 13, can the manager ever enter inside your house?
Yes.
When can a manager enter? An emergency. And an emergency doesn't mean, I've got an emergency, I need to find out if this person has something in their house for me to look at. An emergency would be, hey, Bob's laying on the floor, we can see him through the window, we better get in there, something's happened. Or I smell gas, or I smell smoke, okay? And I'll get your questions in a bit. So that's when a manager can enter. A manager cannot ever enter your home or an enclosed accessory structure without your permission, unless it's an emergency, like what we just talked about. Or the only other situation would be the house is abandoned. If nobody's in there and it looks like, we haven't seen anybody for a while, we don't know what's going on, then they could actually break the lock to enter. But they have to be very careful that they are not doing so where somebody actually still lives there. Number 14, can the manager enter your lot, your outside physical space? I just had this question. A lady up Michelle's Way asked me the question about, we had a lot gate and the manager came in through the lot gate, and isn't that trespassing? Well, if they're not coming into an enclosed deck or accessory structure, I don't know that you can keep them off your lot by locking your gates. There could be very real reasons why they need to get in there, to read utility meters or to do some kind of an inspection. But we draw the line with invasion of privacy, right? Forgive me if I've told this story in front of anybody here before, but it's too great not to tell again. I actually had a case once where the people brought me 8x10 glossy photographs. And one of the photographs was looking out their front window, and the manager was pressed up against the window with a telephoto lens pointing inside. So the picture was background around telephoto lens and the manager's head behind it. Now, is that an invasion of privacy? I think so. And that's where we start the analysis of trying to find out somewhere in between, where do we cross the line? But the manager can enter your lot, presumably to do what needs to be done for management activities. Now, that doesn't mean 2 in the morning. Nobody should be out there at 2 in the morning and probably takes their life in their hands if they are in some places of our state. But that's where the line's drawn. Number 15, capital improvements. Everybody knows what capital improvements are, right? New roads. We just put a roof on the clubhouse. We just redid the swimming pool, the sewer system. The question is, legally, can those be passed through to residents?
Yes. No. If it's in the lease.
I figured I was going to get yeses and nos. That's a good sample response. The answer is, in concept, yes. And there's a California Supreme Court that I quote when you get your answers called Cacho versus Boudreaux that actually says that. That they, in that case, it was property taxes. that can be passed through. However, they need a vehicle to do it. Now, if there's no rent control, they could